When buying and selling real estate, the buyer and the seller will enter into a contract to set out the terms and conditions for the purchase and sale of the property. These terms include the following: the purchase price, the specifics of the property, the date the purchase and sale will complete, any conditions that must be satisfied or waived before the completion, and any other relevant terms to the transaction. Developed by the BC Real Estate Association and the Canadian Bar Association BC branch, the Contract of Purchase and Sale Residential helps realtors and consumers work through the process of preparing a contract for the purchase and sale of a particular property. The Contract of Purchase and Sale Residential includes the most common terms of a real estate transaction and provides a familiar format for buyers and sellers and their realtors to work with, while still allowing for flexibility to insert unique terms. This video provides essential information to help you understand the Contract of Purchase and Sale Residential. How does the process begin, and when is the Contract of Purchase and Sale used? The process begins with negotiating the contract terms. This typically starts when a buyer makes an offer to the seller to purchase the property. Usually, the buyer's realtor prepares an offer on behalf of the buyer using the Contract of Purchase and Sale Residential. Once signed by the buyer, it is presented to the seller as an offer. What information is included in the Contract of Purchase and Sale? The Contract of Purchase and Sale Residential will include basic information about the buyer, the seller, and the property. It will also include the purchase price being offered by the buyer, whether there is a deposit being paid, how much that deposit is, and who will hold that deposit. The contract also includes the date and the time that the offer expires. The duration of the period until the offer expires, which may vary from hours to days, will be determined by the buyer, taking into account market conditions and other relevant factors. In addition to this information, buyers sometimes request that their offer be contingent on certain terms and conditions, such as obtaining satisfactory financing and/or completing and approving a home inspection. What if the offer is not accepted? During negotiations, a party may not agree to all of the terms presented to them in an offer. In this case, that party may choose to propose altered terms and present a counteroffer back to the other party. The parties may continue to exchange counteroffers until they either reach an agreement or the offer is withdrawn or expires. If the parties do not reach an agreement, or the offer is withdrawn or expires, no contract will be formed and neither party will have any obligations to the other under the offer. What happens if the offer is accepted? If the parties reach an agreement and both sign the document, a binding contract is formed between them, and the parties must then carry out their respective obligations contained in the Contract of Purchase and Sale Residential. They should also remember that if the contract is in respect of residential real property, a buyer may have a right to rescind or cancel the contract after giving proper notice and paying a required rescission amount to the seller. What do the terms in the contract mean? And what do I need to know to be prepared to make an offer to buy or to accept an offer to sell a property? It's important that all parties to the Contract of Purchase and Sale Residential are aware of its terms and conditions, so that they know what their obligations are and can carry them out. We will now review some of the important terms contained in the Contract of Purchase and Sale Residential. You should be sure to review the contract in more detail with your realtor before you sign one for yourself. Purchase price. The purchase price is the final price that both the buyer and seller agree on when the offer is accepted. This is the amount the buyer is willing to pay for the property. In the case of residential real property that is subject to the buyer's rescission right, the Contract of Purchase and Sale Residential will also state the required rescission amount, equal to 0.25% of the purchase price, that the buyer must pay to the seller if that rescission right is exercised. During negotiations, the purchase price and the rescission amount, if applicable, may change as the parties exchange counteroffers. Typically, these changes are shown on the Contract of Purchase and Sale Residential by marking up the document, with the buyer and seller initialing the changes to show their agreement. This process will continue until the parties agree on the contract terms, or the offer expires or is withdrawn. Deposit. The deposit being offered is the amount of money presented to show the buyer's good faith commitment to complete the purchase. The deposit will be applied towards the payment of the purchase price upon closing. In some cases, the deposit may be applied towards any damages payable to the seller if the buyer fails to complete their obligations under the contract of purchase and sale residential. The deposit may also be applied on account of payment of the rescission amount owed by the buyer, if applicable. Generally, the deposit for the purchase of residential property in British Columbia is between 5 to 10% of the purchase price. However, market conditions may dictate otherwise. The contract of purchase and sale residential provides that the deposit is due within 24 hours of acceptance of an offer, unless otherwise agreed to by all parties. Terms and conditions. Most transactions have unique terms and conditions that must be documented. This section of the contract of purchase and sale residential is used to include those terms and conditions. Some conditions may state that they are for the benefit of one party and may need to be satisfied or waived in order for the transaction to complete. Examples of such conditions may include the buyer obtaining financing, reviewing and approving an insurance quote, conducting and approving a property inspection, reviewing and approving the title for the property, reviewing strata documents, and obtaining legal and/or professional advice. This section may also include known information, facts, and commitments about the condition or status of the property. The contract of purchase and sale residential is an agreement between the buyer and the seller and should include all terms of the agreement between the buyer and the seller regarding the transfer of the property. Terms that are not included in the contract will likely not be binding on the parties. Matters that are not between these parties, such as between a party and their realtor, should be documented outside the contract of purchase and sale residential. Completion, possession, and adjustment dates. These sections set out the timeline for the transaction. The key dates include the completion, possession, and adjustment dates, which are agreed to by the buyer and the seller when they enter into the contract of purchase and sale residential. Completion date. The completion date is the date when the buyer's money is paid to the seller and the ownership of the property transfers to the buyer. Possession date. The possession date is the date that the buyer is entitled to take possession of the property. In other words, when the buyer gets the keys to the property and is allowed to move in. This date is often the day after the completion, but it can be any date agreed to by the buyer and the seller. The contract of purchase and sale residential will specify the type of possession that the buyer will get on the possession date. For example, the buyer could receive vacant possession, or if there are tenants in the property, the contract of purchase and sale residential may specify that the tenants will remain in the property. Adjustment date. The adjustment date is the day that the buyer assumes and becomes responsible for the costs of the property, such as taxes, utilities, and assessments, and becomes entitled to the benefits of the property, such as rent. To reflect the change of responsibilities and benefits related to the property, the total money paid by the buyer to the seller on the completion date will be calculated so that each party is credited for its fair share. This final amount will be determined as of the adjustment date. The adjustment date is typically the same date as possession. Fixtures and chattels. This section lists the items that are to be included and excluded as part of the purchase and sale. There are two classifications of items, fixtures and chattels. Fixtures are generally objects or improvements made to a property that are attached, physically affixed to the property, or cannot be removed easily without causing damage. Hot water tanks, built-in cabinets, lights, and flooring are examples of fixtures. The contract of purchase and sale residential provides that fixtures are included in the purchase and sale of the property, unless they are specifically excluded in the agreement. Chattels are movable items of personal property and must specifically be listed in the offer if they're to be a part of the sale of the property. Chattels may include fridges, stoves, microwaves, washers and dryers, or window coverings. The contract of purchase and sale residential should specify which of these items are included. If the buyer or seller wants particular items to be included or excluded as part of the purchase and sale, it's important that they specifically list them in the contract. Viewed. This section provides a reference date for when the buyer viewed the condition of the property. The seller agrees that when the property is transferred, it will be substantially in the same condition as on the date viewed. Title. The contract of purchase and sale residential requires the seller to transfer the title or ownership of the property to the buyer. It also provides that the title will be clear of all encumbrances, except for those specified in the contract. As part of a buyer's due diligence, the property's title is reviewed to ensure that the seller is the owner of the property and to see if there are any charges, such as a mortgage, registered against it. It's important to understand that while the title search lists the registered charges that affect the title to the property, it does not provide the details of any charges. Therefore, in addition to having a title search, a buyer should consider obtaining complete copies of registered charges and legal advice to ensure they understand the implications of them. Risk. This section provides that the seller will remain responsible for all risks relating to the property and all other items included in the purchase and sale until 12:01 a.m. on the completion date. The buyer should ensure they have property insurance from and after that time to ensure they are protected. The seller may want to consider also insuring the property through to possession. Restriction on an assignment of contract. The contract of purchase and sale residential provides that the contract cannot be assigned without the written consent of the seller, and that any profit from an assignment will be for the benefit of the seller, unless otherwise agreed to by the buyer and the seller. Agency disclosure. In this section, both the buyer and the seller's designated realtors and the respective brokerages, if any, are specified. The buyer and the seller initial the appropriate boxes to acknowledge receipt of the appropriate agency disclosure forms. Sometimes one of the parties is represented and the other is not represented. In this case, the realtor who represents a client in the transaction is required to provide the unrepresented party with the appropriate disclosure forms to explain the risks of not being represented. The unrepresented party initials the appropriate box on the contract of purchase and sale residential to acknowledge that there is no agency relationship and that appropriate disclosure has been made to them. Acceptance irrevocable. In this section, parties agree that the contract of purchase and sale residential is made under seal and is irrevocable, except as expressly agreed to by the parties, or in the case of residential real property, if the buyer is entitled to exercise their rescission rights. To confirm this intention, parties must insert their initials where indicated. Disclosure of buyer's rescission rights. If the buyer's rescission right applies to the contract, realtors are required to make certain disclosures to their clients. This disclosure is contained in this section of the contract. Both buyers and sellers should review this disclosure with their realtors to understand how the rescission right affects their rights and obligations. Counterparts. The counterparts term helps ensure the agreement remains legally valid, even if the parties sign separate copies of the contract. This means that each party can sign and deliver their own identical copy of the contract, and collectively, these copies form a complete and binding agreement between them. Regardless of whether parties sign the same physical document or use electronic signatures, the contract's validity and legal effect remain intact. Offer. The offer or counteroffer will be open until a specified date for acceptance. Once an offer or counteroffer is accepted by both parties, a legally binding contract is formed. In some cases, the contract may contain conditions for the benefit of a party that must be satisfied or waived by that party before they are obligated to complete the transaction. In those cases, that party should always act honestly and in good faith with respect to satisfying those conditions. This section also contains the buyer's declaration as to whether or not they are a Canadian citizen or permanent resident as defined under the Immigration and Refugee Protection Act. This information will be important for determining whether certain taxes might be payable by the buyer when completing the sale. Acceptance. This section is where the seller signs to acknowledge their acceptance of the terms of the contract. If the seller makes a counteroffer, a binding agreement will not be formed unless the buyer accepts the new terms proposed by the seller. The contract should specify the date the seller either accepts the offer or counters the offer, accepting the terms as countered. In this section, the seller must also specify the residency status under the Income Tax Act by initialing the appropriate box. Residency status is important for determining whether certain withholdings and remittances need to be made by the buyer on closing if the seller is a non-resident of Canada. After the last party has accepted the offer or counteroffer, the date of final acceptance should be inserted at the end of the contract. This confirms the date that the deal is agreed to by both parties. This date is often used as a reference for any terms that may be determined based on the date of acceptance. For example, the date and time the deposit becomes due. Notice for buyer's rescission rights. If the contract of purchase and sale residential is subject to the buyer's right to rescind the agreement under the home buyer rescission regulation, the seller will provide the necessary contact information, such as address, fax, or email, for the buyer to send their notice of rescission. In those cases, the party that accepts the final offer or counteroffer will be responsible for filling in the deadline by which the buyer must exercise their rescission right. This allows all parties involved to establish the date by which the buyer must exercise their right of rescission, if applicable. With such a significant financial commitment, it's important to ensure that you fully understand the terms of the contract of purchase and sale residential before you sign it. If you have any additional questions about the contract of purchase and sale residential, contact your realtor. Realtors are here to help.